All right, let's head over to a good friend of the show, a frequent panelist on the Big Five. Andrew Caddell is on the line, president of the Task Force on Linguistic Policy, also a town councilor in Kamouraska, among his many ventures in life. Hi, Andrew. Welcome back.
Good morning, Elias. How are you doing?
Doing well. So this morning, the reason you're on this morning is because the Task Force on Linguistic Policy has joined the fight against Quebec's Bill 21. That of course, is the secularism bill on religious attire by certain public servants in positions of authority in this province. But there's a whole bunch of aspects to this bill, including the use of the notwithstanding clause, preemptive use. Why didn't you tell our listeners, Sir Andrew, why your group is getting so involved on a bill about religious neutrality?
Well, it doesn't relate directly to the bill itself. What it relates to is the leave to appeal at the Supreme Court. Now, the English Montreal School Board, to their credit, has hived off their case on what we call Section 23, which is the management of minority school boards, and Section 28, which is the gender rights, the rights of women, and which are outside of Section 33, which is the notwithstanding clause. So they've taken their case on those two things, and I give full credit to Joe Ortona and the EMSB for doing this. What we're worried about is that the notwithstanding clause, because it's part and parcel of the case, could be affected. The role of the notwithstanding clause could be affected in the decision of the Supreme Court. And that's why the federal government has said that it will join on this case because, or I don't know if they're going to, but we're hoping they will, because the notwithstanding clause is affected. And that's what we're concerned about, because if the notwithstanding clause is recognized as being able to trump the charter in any way, shape, or form, it means basically we don't have a charter anymore, because anybody can invoke it at any time, and individual rights will go over the board.
So, Andrew, just on, court battles are costly. I've had the discussion with the EMSB about the money they're spending on their challenge, but they say, hey, their budgets are in the hundreds of millions of dollars. So $1 million on a court case, not so bad. All things considered, we've got a large budget. What about for your group? Well, for the Task Force on Linguistic Policy, what's the financial output to join this case? Well,
this is a third front for us. We've already done two fronts. We have a court case with 6 plaintiffs, including myself, who were affected by by Bill 96. And that was in May. We've got an injunction we brought out in January dealing again with Bill 96 and any further application of the law, like the announcements that were made the other day. And this is a third front which relates to the notwithstanding clause. Now, we've raised over $100,000 from individuals across the province and across the country to support our case. We're going to need a lot more money. And anybody who's interested in donating, they can either write the task force at info@thetaskforce.ca, or they can go on our website, www.thetaskforce.ca, and we have a GoFundMe. Or, as I say, if you write us, we can ensure that any donation you make will be anonymous. And we have had large donors who have given anonymously and given large amounts. And we can protect them, and they will their names will never be known, because some people worry about their businesses or their lives being affected if they are known as being donors to this cause.
Isn't that telling, Andrew, that some people, they want to give, but they're worried about being outed or people knowing that they've given to this cause? That is interesting in and of itself.
It's sad, but it's true. And let's face it, there are lots of people in positions of power and in the media who would be quite happy to vilify them in public and put them in the public stocks.
Okay, so let's talk about the notwithstanding clause here, okay?
Sure.
Because it is in the Canadian Constitution. Obviously, what Quebec has done here, the preemptive use is the big change, right? Now, do you think the preemptive use could have been tackled much earlier? Like, do you think it needed to go to the Supreme Court? Were there any mechanisms in place outside of going to court that could have been used to stop the preemptive use?
Well, there's disallowance. The federal government has the right to disallow. In the United States, there are originalists, people who go back to 1776 and 1789 to talk about what the intent of the drafters was. But some of the drafters are still alive.
Yeah.
Jean Chrétien's still alive. Some of the people that were directly involved in the drafting of the Constitution are still alive. And I remember back then, they didn't talk about the preemptive use of the notwithstanding clause. It was a nuclear option that would only be used if there was some law that would cause a problem in its application, and therefore might have to be where it might have to be used. But it was something that was never considered as being part and parcel of the legislative process.
Is it fair to say one of the reasons you're taking part in this bill is because you know a victory here on that preemptive use of the notwithstanding clause would be such a huge boost to your Bill 96 arguments?
Well, no question of that. And in fact, our thinking is that our cases may be put off until this decision is made at the Supreme Court, because if the Supreme Court were to say that the notwithstanding clause can apply and wipe out rights, well, it would mean that the Charter of Rights would have no cause or effect, and it would affect every single case that's before the courts currently, including ours and the other 9 cases that are before the courts dealing with Bill 96.
A lot of this is politics, Andrew, especially when it comes to the federal government and their unwillingness to be part of this battle and the use of the notwithstanding clause preemptively. So let me ask you this, right? There's a federal election that is going to come, latest October of 2025, right? And we look at the polls, and it now seemingly is a 3-way race in Quebec: Liberals, Bloc, and the Conservatives. Are you worried that politics will continue to enter this discussion as to whether or not the federal government will do as they say, which is once it gets to the Supreme Court, now we'll start to talk?
Well, the Justice Minister has talked about that possibility to his credit. However, the Conservatives and the Bloc are looking for nationalist votes. The Liberals are terrified of the possibility of losing seats to nationalists, especially the Bloc Québécois. And we have 3 ministers, Guilbeault, Joly, and I'm trying to think of who the third one is, who are Pascal Rodriguez,
yes,
who are very, very significant nationalists themselves. And therefore, they're really driving the bus on this case. And I think it's going to be a problem, obviously, in the election, because you've got 2.5 parties that are really seeking votes from nationalists and not from the Anglophone community.
Do you know about the timeline here, Andrew? When we could get a ruling from the Supreme Court out of this, if it goes that far?
Well, I would imagine that it would be at least a year. And that would be fast. That would be a quick judgment. Okay,
Andrew, listen, thanks very much for joining us this morning at this hour. We'll catch you on the Big Five real soon.
You bet.
That's Andrew Caddell, president of the Task Force on Linguistic Policy.